Have you ever wondered how GDPR impacts the rights of individuals regarding their personal data? Let's simplify it for you. Welcome to our investigation of data subject rights under GDPR. This act is a significant legal revolution protecting our personal data. Recognizing its importance is crucial for everyone, not only organizations, but also individuals. So what are these rights? First, we have the right to be informed, which obligates organizations to disclose their data usage intentions transparently. Next, the right of access empowers us to view our personal data that organizations hold, following the right to rectification, which entitles us to update any inaccurate data about ourselves. Then we have the right to be forgotten, which bestows upon us the authority to erase our data. Further, the right to restrict processing enables us to limit our data usage. Additionally, the right to data portability lets our data be reusable, which paves the way for smooth data transfer. The right to object is another crucial right, allowing us to oppose data processing under specific scenarios. Lastly, the rights related to automated decision-making and profiling shield us from potential risks arising from automated decisions or profiling without human intervention. Understanding these rights is indispensable not only for empowerment but also for ensuring GDPR compliance. Each right has its unique significance, and together they provide a robust shield for our personal data. Awareness is key, and by knowing these rights, we can better protect our data and privacy. In the next few minutes, we will delve into each of these individual rights. First up, we have the right to be informed. This fundamental right stems directly from the General Data Protection Regulation, its core. It gives individuals the power to understand the treatment of their personal data. Any organization collecting personal data must inform individuals about how it plans to use it. Informed refers to receiving clear, straightforward, and easily accessible information about how data is processed. Individuals must also be informed about how long their data will be stored and any data sharing with third parties. The right to be informed is not just about disclosing data collection, it offers a complete explanation of data handling processes, giving individuals control over their personal information. It's their right to determine the fate of their data, which is possible only when they are fully informed. So, transparency is the key word when it comes to the right to be informed. It's about giving individuals the necessary information and organizations respecting these decisions. Following next is the right of access. This crucial entitlement originates from GDPR. This pivotal legislation establishes a significant control mechanism for individuals over their personal information, allowing them to ascertain whether their private details are being harnessed for various uses. The right of access, however, expands its scope beyond mere verification. Under the parameters of this right, any individual is examined information that organizations have collected about them. This can be likened to a data passport, a powerful tool that unlocks thee to the vast domain of your stored data. It essentially gives you a free pass to explore the labyrinth of your personal data that has been archived by different entities. With this right, you have the power to delve into the intricacies of your data that's being processed. This provision doesn't stop merely at the data. It also allows you to request a comprehensive copy of your personal data that organizations have processed. This essential step empowers you with a transparent view into what specific data an entity holds about you, how it's being used, and to whom it may have been distributed. Moreover, the companies that hold your data are legally obligated to provide it to you under relevant circumstances. Interestingly, they are required levying any charges. This means that you can obtain this data without any financial constraints. If you're tech-savvy and comfortable with electronic systems, you're also permitted to request this data in a digital format, which is a more convenient approach in today's digital age. Remember, organizations must provide a copy of the personal data free of charge in an electronic format if requested. Now let's talk about the right to rectification. This fundamental right is essentially a unique tool that empowers people to maintain the precision and accuracy of their personal data held by various entities. It is a right that grants them the important power to get any false data about them rectified, corrected, or amended. But it's not just about the rectification of false data. The scope of this right extends beyond that. If the data held by a business or entity is incomplete, individuals have the legitimate right to request the completion of their data. Let's consider a scenario to understand this better. Imagine you're a client and a business has your outdated address, which is causing you to miss out on crucial communications and important updates. In such a situation, the right to rectification becomes invaluable, allowing you to intervene and correct this existing mistake. Further, suppose a business only has partial details about you. This could create an incomplete profile, which might affect how the company interacts with you. In such cases, the right to ask them to complete your data profile. This way, you can ensure that the information about you is both accurate and complete. So what happens after making a rectification request? They are legally bound to respond to your request, and they must do so in a timely manner. This is where the General Data Protection Regulation plays a vital role. It outlines a specific time frame for entities to respond to a rectification request. As per the regulation, organizations must respond to a rectification request within a span of 1 month. Note that organizations must respond to a rectification request within 1 month. Up next, we have the right to erasure, also known as the right to be forgotten. This is an absolutely integral provision, emphasized under GDPR. It is a fundamental right that gives individuals the authority to request the removal of their personal data under certain specific conditions. And what are the nature of these conditions? Well, let's take a moment to delve deeper into some of these examples. One such prevailing condition could be when the data is no longer necessary for the purpose it was collected for. This refers to the scenario where the data that was originally collected for a particular reason doesn't serve its purpose anymore. In such a case, you as an individual can request the concerned organization to erase your personal data. Another situation where this right can be exercised when the individual withdraws their consent. This means if you had given an organization permission to use your data and later decide to withdraw it, you can ask them to delete your information. Organizations handling personal data are obliged to respond to these requests promptly. They are required to take quick action and ensure that the individual's request is honored without unnecessary delay. However, it's important to remember that it's not an absolute right. There are certain situations that might prevent the erasure of data due to reasons related to legal obligations or public interest. For instance, data might not be deleted if it's needed for legal claims or if it's being used for public health purposes. This right essentially into play when data becomes redundant or when consent is withdrawn. It's fundamentally about giving individuals control over their data and enhancing privacy. Now let's explore the right to restrict processing. This fundamental right, enshrined in GDPR, bestows upon individuals the power to regulate the management of their personal information. At its core, it captures the individual's prerogative to impede or entirely of their data handling. So, what precisely does this entail? When this right is invoked, the entity involved, such as a company, is obligated to halt their data processing operations immediately. This means they can't utilize the information for any subsequent activities that they may have previously planned or intended. Imagine this right as a powerful pause button on the intricate machinery of data operations. It offers a temporary break in the ongoing flow of data processing, giving the individual a chance to reconsider or review the data usage. This right becomes especially critical when the accuracy of the data is being contested or the process of its handling is under scrutiny. It serves as a window of opportunity, a grace period during which disputes related to data processing can be settled, stemming any data until resolution. However, it's important to bear in mind that although processing is curtailed, data storage isn't impacted. This means that the company or organization involved can continue to the data they already have. The only stipulation is that they are explicitly prohibited from using it further until the restriction is lifted. This is a crucial detail to remember. During the period of restriction, entities are allowed to store the data, but they are forbidden from proceeding with any further processing. During restriction, organizations can store the data but not process it. Moving on, let's unpack the right to data portability. This significant right, afforded by the GDPR, bestows upon individuals an unprecedented level of control over their personal data. It's a principle enshrined in GDPR to empower individuals to have a say in how their data is used and handled. The essence of this right lies in the ability to access your data and, more importantly, reuse it across a variety of platforms and services. Picture a scenario in which you can effortlessly transfer your data from one service provider to another, akin to carrying your personal belongings while shifting homes. This, in essence, is what data portability is all about, but it's not just as simple as the collection or retrieval of data. This right also mandates organizations to present the harvested data in a standardized, easy-to-understand format. It emphasizes ensuring data transparency and accessibility, urging organizations to present data in a manner that doesn't require a deep understanding of data science to comprehend. The data should be comprehensible to the average individual, not just the tech-savvy ones. The right to data portability also has implications for the format in which data is delivered. Organizations are required to provide the data in a structure that is commonly used and machine-readable. Such a format ensures that the data can easily be integrated or transferred into different systems. This isn't just a preference or a bonus feature, it's a non-negotiable obligation under GDPR. Always remember, organizations must provide the data in a commonly used and machine-readable format. It's not just a nice-to-have, it's a must-have under GDPR. Next on the list, we have the right to object, a critical part of GDPR. This particular right represents a powerful tool for individuals when it comes in controlling how their personal information is used. It's much more than a piece of legal jargon, it's a substantial right that comes with its stipulations. Right to object is not just limited to a single application, it can be invoked under a variety of circumstances. These include, but are not limited to, instances of direct marketing, instances where the data usage is based on legitimate interests, or even instances where the data is used for research and statistical purposes. So what does this mean for you in practical terms? Consider this scenario. A specific organization uses your data for marketing purposes or to further its own interests. Under the right to object, you have the power to dispute this. Similarly, if your personal data is being used as part of a research project or for statistical evaluation, you can assert this right and object to this use. In such circumstances, the organization in question must using your data unless they can demonstrate substantial, legitimate grounds for the use. It's important to note, however, that the emphasis here is on the organization to prove the legitimacy of their grounds, not on the individual to disprove it. The fundamental principle of the GDPR is to empower individuals by placing greater control of their personal data in their hands. This right, in particular, provides individuals with considerable authority and control over how their data is used. This right offers individuals considerable control over their data. Finally, let's delve into the rights in relation to automated decision-making and profiling. GDPR serves as a shield in a virtual world dominated by technology. It primarily tackles decisions made without human intervention. Consider a financial system that automatically approves or rejects your loan request based on your credit score. This is where GDPR plays its part. Profiling is another aspect that GDPR addresses, where personal data is utilized to evaluate certain factors like economy, health conditions, or individual behaviors. The GDPR highlights the need for safeguards against harmful decisions made without human engagement. Let's talk about the core principles of these rights. The first one is the right not to be on the receiving end of solely automated decisions. The second is the right to intervention in decision-making processes. The final one is the right to challenge the decision that has been made. These rights underline the significance of human involvement in these processes as we progressively integrate more technology into our lives. They are indispensable in a time where automation and AI are becoming increasingly prevalent. A thorough comprehension and respect for these rights is the key to a future where technology improves our lives without encroaching on our basic rights. And by understanding and respecting these rights, we can ensure a future where technology enhances our lives without compromising our fundamental rights and freedoms. Now that we've explored each of the rights under GDPR, let's summarize. GDPR compliance hinges on these rights dedicated to protecting personal data. The right to be informed promotes transparency in data collection and usage. The right of access assures individuals can obtain and verify their data processing, with organizations required to provide a copy. The right to rectification permits inaccuracies in personal data to be rectified promptly. The right to erasure, or right to be forgotten, facilitates personal data removal under certain circumstances. The right to restrict processing lets individuals to limit their data processing. The right to data portability guarantees data reuse across multiple scenarios. The right to object allows individuals to refuse processing based on particular interests. Rights in relation to automated decision-making and profiling, and as a profiling shield against decisions made without human intervention. These rights demand organizations' comprehensive policies. Moreover, it's essential to mention that GDPR rights are not absolute and apply in certain circumstances. They also work in balance with other fundamental principles and rights. For example, freedom of expression and information, or the necessity data processing to comply with legal obligations. In conclusion, organizations should aim to strike a balance between their operational needs and the privacy rights of its data subjects. It's about respecting privacy, ensuring transparency, and building trust. Remember, organizations must be in facilitating these rights. Stay informed, stay compliant.